Hey everyone, good morning. My name is JD Houvener and you've made it to the Bold Today show. I'm the CEO and owner here at Bold Patents Law Firm, and I'm here every Wednesday, 9 a.m. on the West Coast and noon on the East Coast. So bring all those questions for you inventors, entrepreneurs, business owners, or those just curious about what patent law is all about. As a patent attorney, I'm here to answer those questions. But just so you know, do not raise any confidential questions. Please keep those to yourself for now. If you want to bring them up to me confidentially, I encourage you to do that. What I'll do is I'll put my information down a little later in the show, and you can send an email directly to me. And of course, you can also schedule time with our advisor to see if right now is the time for you to get started. I know a lot of you inventors are out there kind of worried about whether it's the right time, if patenting is right for you. And so what I'll do is I'll put that link in for you to be able to make and take action today. So there's that link right there. It's a Calendly link where you can schedule time, free schedule appointments with one of our advisors, our non-attorneys, to see if at this time, if you've got what it takes, if you're far enough along in the development to move your invention forward and ready to speak with the patent attorney. All right. So today, I was really hoping to talk about market-ready designs, and I had a wonderful guest lined up for you. Unfortunately, he fell ill just yesterday, and so we're going to miss him today. So we'll bring him on the show in a later segment, well, future week. In other words, we'll be able to talk about market-ready designs at that time. For now, I'm happy to field any questions about patents with respect to designs, and I'll also include a link to a blog article that I wrote just a year and a half ago on design and design patents and drawings. But I can't, of course, speak specifically to what it's like working with inventors on the design side at this moment, because I want to make sure we give that airtime to our guest. So all that said, let me do this, and I'll jump into our avo.com questions. I've got a couple questions that have come in this week, and so we can jump to those right now as we wait for our live audience to join. Looks like we have two in trademark and one in patents. So this first question is coming out of Cedar Rapids, Iowa. Okay, so let me pull this question up and I can share this with you all right from the screen. Okay. Hey, Jody, nice to see you. Thanks for joining. All right, so this question is, I'll pull it up here too so you can see it. All right. A highly complex patent likely to get a restriction requirement filing in the US and PCT in August. How does PCT work with restrictions? Our current patent draft is about to be filed with the US Patent and Trademark Office. However, it has 4 different unique ideas that are unrelated. So it's got 4 distinctly patentable inventions. It will likely be asked to be split up. We're filing both US and PCT soon, and I have no idea how PCT restriction requirements work. Extra fees, or will I be asked to file additional PCTs? Also, our current lawyer kept all of my office actions, which I don't mind. Here, see, which I don't mind. Our whole strategy is to spread the cost of several patents over a large period of time. As a micro-entity, this is vital. Cool. Well, I like this. It's a good question. It's fairly specific. So for those of you who may not know what restriction requirement is, let me just give you a little bit of context. So when you file in the US, that's of course where I'm going to be able to speak most knowledgeably. When you file a non-provisional patent application, which is the formal utility app, where you try to protect the functionality of an invention, the patent office will assign an examiner, okay? And as soon as they do, which can take up to 6 months, right? So it can take quite a bit of time to find the right examiner for your specific invention. The first thing they will do is make sure that, hey, you're only submitting 1 invention per patent application. They don't want to be on the hook to do 4 searches, okay? 4 times the amount of searching if they're only getting paid for 1, set of 1 actual patent. So you're only allowed 1 invention per patent. And so that's their job initially, is say, okay, how many inventions do we have here? And the person asking the question is smart enough to know that they probably have 4, distinct inventions, and they decided to file them all into 1 claim set. Okay, what stuffed it all into 1 patent application. So what a restriction requirement is the examiner saying, I only have time to look at one, and you've got to pick one. Okay, these are the four, right? Claims 1 through 3 are invention 1. Claims 4 through 7 is invention 2. Claims 8 through 15, invention 3, and then claims 16 through 20 is the last invention 4. Tell me which one you want to move forward with. Okay, we're going to restrict the patent application, and so you might elect, okay, let's go with invention 1, claims 1 through 3, and so claims 4 through 20 will be restricted. Okay, sort of put off to the side, and you have the ability to then file later what are called divisional applications, where you actually have a brand new, in parallel patent application for up to 3 more inventions. So you could, in theory, have 4 pending applications before the patent office, but you've got to pay those fees. Okay, and you've got to be able to. The examiner is going to want to get that allotment of time to do their search and examination for each of those inventions. Okay, so that's kind of the background on what a restriction requirement is. With respect to the PCT, okay, Patent Cooperation Treaty filing, okay, all that, what that does, okay, does quite a bit, but one of the major benefits that it provides is it allows more time. Okay, so you file in the US, let's say January 1st, 2021, you must file in foreign countries by January 1st, 2022. Okay, it's 1 year, okay? And if you don't know which countries you want to file into, this can be pretty stressful. And so the PCT does is it says, okay, you must file the PCT, which is a treaty that over 150 countries are part of. They have all agreed that, okay, we're going to acknowledge the one search that's done by the US examiner. And we're also going to allow additional time for that US-based inventor to decide which countries they want to file into. So it buys you a whole 1.5 years on top of that 1 year. So it's a 2.5 years, 30-month period where you get to now decide, okay, which countries do you want to file into? So it's really a placeholder, okay? There's no examination that happens through the PCT itself. The PCT is just a vehicle that you can then file into the foreign countries with. Okay, it basically buys you the ticket to be able to have more time and have saved them money. And those foreign countries, let's say in the UK or in Australia or Korea, those examiners in those different countries will all be obligated to use the search result that the US examiner, acting on behalf of the whole world under the PCT, performed. I know I'm throwing a lot of information at you, but it was a detailed question, so I think you wanted a detailed answer. So the further question is, well, okay, how do these restricted 4 separate inventions apply, or how does that work with respect to the PCT? Will I have to file multiple PCTs? And the answer is yes. Yes, you do. The Patent Cooperation Treaty, you have one filing, okay? The PCT effort will only give you that priority back to the one application, okay? So if you want to then seek international protection for those 3 other inventions, if you filed those separately through other divisional applications, yes, you will have to file separate PCT or foreign filings. The beauty is, though, you probably should hold off, right? If you haven't finished prosecution with the examiner in the US first, you should probably wait, because you have time to see how things go on that first invention. And if things go well, great, I think proceed right to the second divisional and then also look to file. But it could be that you get all the way through prosecution before the 18 months is up. And so you'll be very wise to know how many PCTs to file to get the best bang for the buck. Okay, long-winded answer. Thank you for hanging in there. Bindu, nice to see you. Thanks for hanging in. So if you're new to the channel or you're just joining it for the first time, I'm JD Houvener. I'm a patent attorney and owner here at Bold Patents Law Firm. And I'm happily to answer any live questions you've got. I will prioritize those over anyone else. Looks like Flavio, you got a question? You bet. Yeah, you're welcome. Yeah, for going live. When someone buys your patents, do they officially become the inventor? No, sir. Great question. The difference between inventorship and ownership is something we have to explain, and we're happy to do it. Inventing, you have to be the inventor. Okay, you have to be the one that has the idea, that conceives of that solution. Okay, that will not change. Even for inventors that are in big, huge companies, let's say Microsoft or Amazon, they must be named by first and last name, even if of course Mother Microsoft or Mother Amazon is going to own that, right? Because as an employee, usually you're obligated to assign, meaning transfer the ownership of the invention to your employer. They'll be listed as the assignee, but the inventors will always be there, okay? And there are certain rights that come with that. But usually, like I said, in employee-employer situation, those rights will be assigned, and there will be a separate recording of that assignment in the patent recording database. So, nope, inventorship stays the same, while ownership can certainly change hands quite a bit. Okay, so let's jump to a second. We had a second and third question on AVO. That was the only one we had on patents, but it was a really good one on the implications of PCT and divisional US applications. So on to trademarks. I know we're bold patents here, but we do certainly help inventors and entrepreneurs that want to start and grow a business, help educate them about trademarks, and we do help research and apply for trademarks at the federal level too. So here's a trademark question. I'll bring this over to the board. Okay. I'm wondering if I can create a trademark for my cryptocurrency, Mercury currency, but there's already a cryptocurrency, Mercury Cash, that is registered. Question mark? So let's assume that there is a Mercury Cash out there that is already registered at the Federal Register at the USPTO. And they are in cryptocurrency. I think it is extremely high likelihood that if you were to apply for Mercury currency, that you'll get a rejection, just based on the fact that it's not distinct over and above Mercury, and also that it's confusingly similar to Mercury Cash. So yeah, I mean, even though you're changing the word currency versus cash, I think those names are synonymous and even actually descriptive of cryptocurrency, right? Currency being part of cryptocurrency. That's like, in terms of, perhaps a more tangible example, let's say you're selling hamburgers, Mercury burgers, okay? The Mercury part is what's distinctive, right? That's not necessarily having anything to do with a hamburger, right? What you're selling. But burgers is, of course, and so you'll likely have to disclaim. You won't be able to you'd be the only one that can call yourself burgers if you're selling hamburgers, because it's just describing what the products are, merely descriptive. And so the term Mercury is the only part that's truly distinctive about your mark. And so that is likely, very likely to be a point of contention where the trademark examiner will say, sorry, this is already taken, okay? Now there's not necessarily the end of the road for you. You may be able to work with Mercury Cash to get a license, maybe be able to use that mark. And perhaps there's sort of sub niches or sub industries within cryptocurrency. I don't know, for example, if they're like a wallet, and you're more of a behind the scenes B2B validator, right? I'm not necessarily in the industry, but if you're doing some of that data validation and you're more behind the scenes B2B work, and they're more B2C, and they don't mind if you use the word Mercury, and they may just want you to pay them a royalty for using that term Mercury currency. If you're really not competing with them, okay? But the trademark office probably won't know that. So anyway, just hopefully a little context for you on the trademark side for that. Okay, well, I don't see any more live questions. I'll do one more question here from our AVO community. This one is from Eatontown, New Jersey. All right. Okay, do you think it'll be a problem if I trademark my rap name, NFL, even though it stands for something different than National Football League? Trying to trademark my rap name, but feel like it will be a conflict. So should I spell it out, or can I leave it as NFL SAVV, even though NFL has a different meaning? I see, sure. So, I think it's going to take some research on this. Certainly, I think you're off to a good start in terms of not being in the same industry or same competitive space. In the last example we saw, you had Mercury currency versus Mercury Cash, and they're both in crypto. I think that's going to be a major conflict. You're selling music, right? You're creating a record label. You're producing, lyrics, musical compositions, in terms of, how you're selling, what you're putting out to the market as NFL. Okay, very different than, right, the sports and entertainment industry of football through the National Football League and NFL. That said, okay, there are many marks, and I think NFL may be one of them, that over enough time, okay, when you think of Starbucks, Google, Amazon, and these huge mega brands, they become famous, okay, and they get extra privileges when you become famous. And their goodwill and their notoriety goes beyond their classification, is a technical term. It goes beyond football, it goes beyond sports. And if you're using the term NFL to really sell anything, okay, and certainly including music and rap, because NFL is triggered in many people's minds, many customers' minds, the thought of their argument would be you're still taking away from the NFL brand and their goodwill, even though you're selling a completely different product. So that's where we need to research. I'm not going to give you a straight answer right now. I think we need to do some research on how pervasive is NFL mark in terms of what likelihood you'd have in having success there. And it would be a sort of a likelihood of confusion analysis to see whether you'd have success. But it's sort of iffy. Can't really give you a clear yes or no on that, but it's a good question. So thank you. All right. Well, I know the topic was market-ready designs. For those of you that may be hanging in there trying to hear some tidbits on that, I don't have a prepackaged presentation on market-ready designs. Like I said, I was hoping to bring on our guest, but he just had to bow out yesterday because he felt ill, but I'm hoping he's able to recover soon. We'll have him back on the show to talk about design, prototyping, development, and how to bring physical products, but even digital products, how to do some rendering, some interesting ways to bring them to market and show them in a professional way. So it'll be on a future show. I think I'm going to wrap up. Okay, so please bring those questions in, keep it coming, give us a like on social. Come back here next week if you have further questions. I'm JD Houvener, owner here at Bold Patents Law Firm, and it's a pleasure being with you. All right, take care, everybody. Have a good day. Go big, go bold.